If there is one interruption by you, you will be held in contempt of court. What it is you want to say or not, because you're interrupting me. Okay, now I'm holding you in contempt. I've given you one chance right now. The court is going to indicate.
This guy thought he could just walk into court and talk over the judge like it was no big deal. Well, he learned the hard way that interrupting the judge isn't just bad manners. It's practically an invitation to a one-way trip to jail. He tries to represent himself, spouts off a bunch of sovereign citizen nonsense, and by the end of it, the courtroom turns into a complete chaos. And trust me, you'll be shocked at how many days he gets for contempt. Spoiler alert, it's way more than you'd think for just running his mouth. The judge shuts him down pretty quickly, but here's the real question. Was she too harsh, or was she just done with the whole circus? Let me know your thoughts in the comments. Now, let's dive in and check out this meltdown.
State of Michigan versus Shadid Howard Randolph 23302. And appearance for the people, please.
Good morning, Your Honor. He's at BOP 214.
Thank you. And Mr. Howard Randolph, your name, please.
Shadid Howard Randolph.
Okay, so before we go any further, I'm going to make this statement. I'm going to indicate the last time you were here in court, sir, which was April 20th, there was significant disruption to the court record. So I'm going to state this. If there is one interruption by you with anybody that's talking on the record, whether it be the prosecutor, your attorney, any witness testimony, or the court, you will be held in contempt of court. I just want to make sure you understand that. Do you understand that?
Did I do something wrong? You said I did something wrong.
What I indicated is the last time you were here in court on April 20th, there was a lot of interruptions. Not a disastrous record.
Stop.
You had a disastrous record. So what I'm indicating, so I can make sure that we have a clear record and that I am maintaining order in the courtroom, that there will not be any interruptions by you, whether when the prosecutor is talking, your attorney is talking, any other witness, or myself. If there are any interruptions by you, Mr. Howard Randolph, this court is going to hold you in contempt of court. Do you understand that?
Yes. And Your Honor, my client understands that I will be speaking for him today, pretty much for the majority of this proceeding. So I don't believe that's going to be an issue. But thank you, and we're well noticed that everyone has to wait their turn to speak. Thank you for the notification. No, not. Just record my motion. Just stand there quietly. I wouldn't hold the talk. Just interrupt me. We're ready to proceed, Your Honor.
Okay, Ms. Ozera, would you like to address the court? If you can step forward, please.
Mr. Honor, I am representing the stuff in the custody matter, and with regard to Mr. Howard Randolph potentially being in custody, that was something that we did inform the judge of yesterday, and he said that he would accommodate as necessary if that is the case. I plan to appear as soon as I am back to my computer to inform the judge of the way that these proceedings conclude. I would also like the court to note that while it's been made clear to Mr. Howard Randolph that there is no contact electronically or by other means, that throughout the trial proceedings, Mr. Howard Randolph has continually directly addressed Ms. Duff during the proceedings, which would violate the no contact. And I believe that that will continue to happen. The forum of Mr. Howard Randolph today might be great, but throughout the Zoom trial has not been great, and he has made threats and has spoken in threatening ways to myself as well as Ms. Duff.
And when you indicate that Mr. Randolph has been addressing Ms. Duff directly, Is that during Mr. Randolph's turn to ask questions? Is he representing himself?
He is representing himself. It has not been with regard to any direct examination of Ms. Duck. He has not chosen to, at this point thus far, to question Ms. Duck personally or cross-examine. This has been in his statements to the court, which then devolved into him directly addressing Ms. Duck.
And Your Honor, we're going to be in the process of getting the transcripts of that particular hearing this week. We don't know the specifics. If the court were not inclined to reduce further, I would only ask for this one allowance that my client just financed a vehicle. It's in the parking lot. There's no one else to get the vehicle. He has to buy the one drive to the address I indicated that it doesn't fall within the things that I do. And I asked that my client get a report later today, if not tomorrow, so we can just take the car back. And not only is he going to be missing the hearing, he's going to be going to custody. I don't want him to be in a position where his car is towed and he's going further and further down an avenue that we're just trying to halt and put back into an advantageous position. He understands that if he fails to appear, the consequences are going to be it's going to be catastrophic. So that would be the only allowance if there would be no bending on any further bond conditions, that he be able to report in custody after taking his car.
Okay, I can appreciate that, counsel, but Mr. Randolph can leave his key at the window with the police department, and we can make sure that they're not having it towed, and then his girlfriend can come pick it up. I'm not giving him a report date, not at all. I have serious concerns for safety and compliance with this court's order. So the court is indicating 10,000, 10%, no surety, GPS tether in the event bond is posted. You can leave your key with the police department, and then we'll make a note that with what your vehicle is, so that it's not towed and that somebody can pick it up within the next 24 hours or so.
This is where everything starts going south in the courtroom. The judge actually gives this guy a break, letting him keep his car from getting towed since it's about to be hauled off to jail. You'd think that would chill him out, right? Nope. If you saw his last hearing, you know this guy's like a walking alarm clock. Loud, obnoxious, and impossible to silence once he starts. He hasn't even said a word yet, and I'm already mentally preparing for the meltdown like it's a season finale. It's honestly wild how some people treat court like it's an open MIC night to air their entitlement issues. Like, bro, this isn't a debate club. You're one outburst away from contempt charges and an extra night behind bars. Anyway, hang tight. It's quiet for now, but trust me, the storm is coming.
That's up to your attorney. Sir, let me just be very clear. Your attorney would advise you whether or not you should or should not address the court based upon what it is you want to say or not, because you're interrupting me. Because something you say could be used against you. So that is why I indicated if your attorney suggests that you speak. Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly tending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to indicate 15 days jail for contempt.
Honestly, 15 days kind of feels like the judge just wanted some peace and quiet from this guy's voice. It's like she ordered up a little court-approved silence. I get it, Dave. He wouldn't stop interrupting. But locking him up for that long, that's not justice. It feels more like a noise-canceling measure with a legal stamp of approval. But hey, what do you think? To me, this whole thing feels less about the crime and more about the vibe of the situation. And we all know that after this hearing, this guy's probably going to walk out like he's some kind of hero, thinking the court couldn't handle his truth. Meanwhile, he's one outburst away from trying to live stream from a holding cell like he's exposing some government secret. The law gives judges a lot of flexibility with contempt charges. 2, there's no set rule, so technically, she could have thrown 30 days at him just for having the audacity to have a bad attitude.
The court's going to also indicate that while, sir, you were quiet and not interrupting this court's order nor the proceedings, towards the end of the proceedings, then you began to interrupt this court. Despite this court's order not to.
Not to speak my mind?
Not to interrupt this court.
I didn't interrupt.
Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay. But if you file a false police report, you let it get in your courtroom. So the prosecutor,
Sir,
Sir,
you may file anything that you
June the
choose.
1st. Hey, listen,
You
this
may
domestic violence
stop interrupting.
You're gonna
Stop interrupting. Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the
Real, I'll tell
17th.
you, baby.
You're not to address,
Okay, I'm addressing the bar though.
Sir, the court's adding your next 10-day time for you addressing the victim in this matter. It's a full 25 days. Off the record.
That line easily earns a spot in the Courtroom Hall of Fame for worst things to say right before sentencing. Like, if you're trying to get the judge to go easy on you, maybe don't wrap it up with a full-blown insult to the entire legal system. That's not rebellious. That's just fast-tracking yourself to an extra week in lockup. Honestly, the only thing missing was him flipping a table or butchering a quote from the Constitution while calling the witness baby. That wasn't bold. That wasn't clever. Honestly, it was just weird. I don't know how you feel about it, but to me, 25 days feels a bit heavy for that meltdown. Then again, the judge clearly came in with both time and energy to spare. Anyway, let me know your thoughts in the comments. If you enjoyed this one, make sure to like and subscribe. Thanks for watching, and take care.